And the legislation that President Bush was referring to is immunity from lawsuits for telecommunications companies. That's our topic this week on the Communicators. Marc Rotenberg of the Electronic Privacy Information Center, you were quoted after the Senate passed their version of the bill. You were quoted as saying that this is a very bad day for communications privacy law. Why?
Well, I was disappointed by the Senate measure. Essentially, it gave the telephone companies immunity for what were likely violations of privacy laws that took place after 9/11. And the key concern I think that many people have about the Senate measure is that it effectively undercuts our system of checks and balances. It prevents individuals from having their day in court, at least being given an opportunity to make the case that their rights were violated. It's not necessarily the case that that will be established, but the President's proposal, which is what was incorporated in the Senate bill, effectively takes those claims and says they don't get into court.
In your view, what are some of the violations of privacy law that happened?
Well, I think the critical point to understand is that we have a very good framework in this country to protect the privacy of communications, generally speaking. Telephone companies have an obligation to their customers to ensure the privacy, the confidentiality of those communications, and there are also procedures that permit the government to go to the telephone companies and say in certain instances we have a warrant, we have a subpoena, there's judicial authority, we need your cooperation, and the telephone companies under those circumstances should rightfully comply. We're talking about the case where those procedures were not followed, where in effect the government goes to the telephone companies and says, we really need your help, but we don't have the authority of the judge, and we know there's some laws in place, and we think you need to ignore those laws. Those are the types of claims that we think should be brought before a judge and evaluated.
Patrick Philbin is a former Justice Department official and an attorney here in Washington, D.C. Do you agree with Mr. Rotenberg?
No, I don't, and I don't agree particularly with the characterization that what happened here. We're talking about allegations that phone companies were participating in some activity, and I don't want anything that I say to be taken as a confirmation that any activity that went on, but the allegation is not, the circumstance should not be understood as the government went to telephone companies and said something like, we know there are these laws and we can't get these orders and we want you to help anyway. The premise of the legislation, as spelled out in the report from the Senate Intelligence Committee, is that the situation that would be assumed for the immunity is that the President of the United States himself had authorized an intelligence program, that high-ranking intelligence officials had asked the companies to cooperate, and they had been told that it had been approved as lawful by the executive branch of the United States government, by the Justice Department. So that's the only circumstance you're talking about for the immunity, is where the government has made a representation to the telephone companies that this has been examined and this is lawful. And I think that the question then really is, what is the right thing to do in a situation where, in a circumstance of public emergency, of true public need, the government comes to someone, says, we've looked at this, our law enforcement officials say this is lawful, we need your help. Companies go ahead and help, and then afterwards they get sued. And the principle that I think the President is advocating and that the Senate overwhelmingly voted in favor of is that in that circumstance, the company should not be held responsible if someone later thinks that the government itself made a mistake in assessing the legality of that.
So you're not necessarily defending the program as such. You're defending the fact that companies responded to a public need.
Correct. I mean, for this discussion, I would, in other circumstances, take on the issue of the program if we were talking about, hypothetical details of a program. But I think that the principle for immunity, and it's one that goes well back in the common law, is that law enforcement officials, there is a well-established common law doctrine, can call upon the citizen to aid in effecting an arrest or in doing something like that. And if the citizen believes that the officer has the authority to call upon him and assists, but it later turns out that the officer was wrong, that citizen is held immune if he has a good faith belief that he's told he can do this lawfully. It's a similar principle that should apply here, and a similar principle that the Senate, I believe, was relying on and invoking in passing that bill.
What about Mr. Rotenberg's point, though, about checks and balances? Does this give too much power to the executive branch?
I don't think it does, and I think that the appropriate place to look for checks and balances here, we're talking about an intelligence program, is not private litigation. I think that that's one of the arguments in favor of not having immunity that really ought to be examined and taken apart, because the conduct that is at issue that people believe is wrongful in some ways, that the government was involved in an intelligence program that it shouldn't have been doing, that it was making a mistake about the extent of the law. The way to address that issue is not to have private litigants in public courts trying to ferret out the details of national security programs. That's going to be damaging for national security. Having anyone who cooperated be hung out to dry after being told what they were doing is lawful is going to have a significant effect on participation in all sorts of areas where law enforcement, other government entities seek cooperation from the private sector. That's why hundreds of organizations, police organizations, 21 state attorneys generals, others have written letters to Congress in favor of this immunity, because law enforcement, other governmental entities need cooperation with the private sector all the time. And the principle that would be established if this immunity is not provided, if the assurance is given that what you're doing is lawful, is then pulled back and the companies are left to be sued, that's going to damage that cooperation. And the place for really getting the checks and balances and the regulation is not through the litigation, but through congressional oversight. That's where an intelligence program has to be examined, and that's where the oversight has to come from.
Well, I disagree with Mr. Philbin's characterization of the immunity doctrine. I mean, certainly there are circumstances in conventional settings involving law enforcement where immunity may be appropriate, but we're talking about a very specialized setting. There is a lot of interaction between the government and the telephone companies on a routine basis involving disclosure of records and the interception of communication. These laws have been in place. Actually, the original federal wiretap law goes back 40 years. The FISA were the amendments that were adopted in 1978, and there's a very clear understanding, I think, between the telephone companies and their very good lawyers and the government about the circumstances when these type of activities may occur. We also know that in this specific instance, there was at least one telephone company that was not comfortable with a request from the White House to participate in the program. That was the Quest company. They believe that they were subsequently punished by the federal government, were denied the opportunity for certain contracts because they did not participate. So in this circumstance, I think what immunity actually does is two things. One, it tends to reward people who don't follow the law, because the companies that are trying to uphold their privacy obligations end up being punished. And two, I think it sends a message that in the future you may not be required to follow the law, which could actually undercut some of the cooperation the proponents of the legislation have in mind. Think about federal wiretap law as a program that makes clear the circumstances under which the companies are effectively safe when they comply with the government, and the circumstances where they may get into some trouble. I think under Mr. Philbin's analysis, if the government grants this retroactive blanket immunity, it sends a message that that line can be moved. It can be changed from one day to the next, and I think the prospects for cooperation under these circumstances would not be so good.
I disagree with that sort of assessment of what the likely effects of immunity would be on cooperation, and really with the characterization of what the immunity is. This is not a blanket retroactive immunity. The statute, the bill that was passed by the Senate, is very narrowly tailored to a specific circumstance. It talks about a program authorized by the President of the United States himself, only within a certain time period, relating to threats of foreign terrorist attack, and in a situation where a company was given a specific representation about the legality of the program. That's not opening a door to, well, you don't really have to follow the laws, just help us out. This is a very limited set of circumstances in which the possibility for immunity would arise. And if, given the assumption that all of those factors occurred, assume that all of those things occurred and telephone companies had done something on that basis, which is the assumption of the Senate Intelligence Committee report, then not granting the immunity would suggest that you can't take the U.S. government and the Department of Justice at its word when it tells you what you're doing is lawful.
But of course this becomes a bit circular, because it's the program itself, the one which the President initiated, that many people believe was unlawful. And the illegality occurs when the telephone companies disclose the information about their customers without the warrant. So for the President, in effect, to be able to say to the telephone companies that the program that he authorized, which was not lawful, they should not be held accountable for, because he's now giving them this permission, would seem to undercut the laws that we're so interested in trying to protect.
Mr. Philbin, the New York Times recently opined that the Bush administration wants to stop the discovery of these records, wants to push for the immunity so that the real action cannot be discovered. What the Bush administration actually did will stay covered up.
I don't know about that sort of allegation. I think that there is a real national security interest in not having private litigation become a mechanism for disclosing a sensitive intelligence program. And I think that that is a true interest that is also served by the immunity. Some people think that the state secrets doctrine would be an answer to that, that the government can assert the state secrets privilege, and that will prevent anything from being disclosed in the litigation. But I don't think that that is really a cure-all for the situation. If it were, the litigation wouldn't still be pending after, I think it's over 2 years now. And there is a danger that sources and methods, the kind of things that, if there was an intelligence program like this, the kind of things that it was targeted at, could leak out if litigation were to continue. And I think that's another argument in favor of granting the immunity.
Do you think that there is some kind of a cover-up by keeping this law?
Well, I think there's clearly an attempt to prevent public scrutiny and even congressional scrutiny of the activities that the administration is now seeking to have protected under the immunity proposal. And that's actually quite remarkable with respect to the Congress. We have members of the Senate who actually voted on the immunity proposal who are not familiar with the underlying actions that Congress, through this vote, would effectively put beyond the reach of the courts. I think that was actually a terrible mistake. I can understand why some members of the Senate may have done this on behalf of the President or the strong urging of the telephone companies.
The vote was 68 to 29. That's a pretty strong vote, isn't it?
Well, it was a strong vote, but it was also the case that many of the members of the Senate who voted that way were not familiar, could not in fact have been familiar with the underlying activity that they were now saying would not be investigated. And I think members of the Judiciary Committee in particular, who had a competing proposal, one that I think would have provided for some accountability, were surprised by that outcome.
But I'd like to respond to the idea that you mentioned the word cover-up, and Mr. Rotenberg was suggesting that there is an effort to prevent even congressional scrutiny. And I think both of the, as far as I know, both of the intelligence committees, House and Senate, have been fully briefed, all members of those committees, on everything to do with any activity related to the program that the President announced, the terrorist surveillance program. And additional members of both houses have also been briefed, not the full membership of both houses, but a sufficient number of those on the key committees who understand everything that's going on and have the oversight responsibility for intelligence operations. And it was the Senate Intelligence Committee that overwhelmingly recommended in favor of this immunity.
Well, let me say two things. I mean, first of all, it is only the Senate Intelligence Committee among the committees of Congress that consider this matter that favored immunity. The Senate Judiciary Committee rejected it. Both the House committees rejected it. So that is within the Congress minority position. But I also should say that I have a personal interest in the question of cover-up because EPIC, my organization, filed a Freedom of Information Act request the day the New York Times reported on the domestic surveillance program. And we were specifically interested in the legal memos that justified the President's activities. Now, Mr. Philbin knows a bit about this and probably can't speak to it on your program, but those memos go into the central question as to the legal basis that would permit surveillance of American citizens without judicial approval. It's been over 2 years. Those memos have not been released to us. They've not been released to the public. They've not been made available for scrutiny. We're not talking about compromising methods or techniques or any ongoing investigations. We're just trying to understand what is the legal basis that was before the Department of Justice at the time the program was undertaken that led the government to believe it could do this.
Well, I think that shows we're getting pretty far beyond the idea just of immunity, and that's why these lawsuits, I think, in some ways are not about just the telecommunications carriers. It's not about just immunity for them. It's about ways and hooks and angles to find out more information about an intelligence program or about legal advice that should remain confidential. And the administration did put out a white paper from the Justice Department that set out the legal justification. The fact that the internal memos that were originally generated, which were confidential legal advice, were not disclosed, I think, is appropriate.
Senator Levin proposed an amendment which failed that would have replaced the telecommunications companies with the government as the defendant. Do you support that?
Well, I do, actually. Senator Specter and Senator Whitehouse, I think, had a similar proposal, and the concept is called substitution. It effectively creates an opportunity for the people who brought these claims to have a defendant. And if the government feels so strongly that it should not be the telephone companies, then it should be the government, perhaps, that takes the responsibility for defending these claims. In my view, it would be appropriate to bring the cases against the telephone companies, but the alternative that's currently on the table, which would be full immunity and no one held accountable, I think is clearly not a good outcome.
$40 billion lawsuits or something
Right.
like that, some number like that. If it were allowed to go forward,
well, this is kind of a silly argument. I think actually the Vice President made this argument, a few weeks ago, trying to explain why immunity was so important. And, apparently someone takes a calculator and, puts in the provision of the code and the number of offenses and the number of telephone customers in the United States and comes up with a very big number, which, by the way, is still less than the annual budget of the National Security Agency. But this, of course, is what we have courts for. I mean, courts make determinations as to culpability. They make determinations as to damages. If courts award damages that are considered too high, defendants go to appellate courts, damage awards get reduced. I actually thought that was one of the silliest arguments, in favor of immunity.
it's an argument that you used, though, in a letter that you and former Attorney General John Ashcroft sent to Senators Leahy and Specter.
Mm-hmm. I think that the liability that the telecommunications carriers would face from these lawsuits is part of the damage, the risk that they are being held exposed to is inherent in the downside that they get from taking the government at its word under the assumptions that we're talking about for this scenario and providing the assistance that the government requested. And they shouldn't have to have that disastrous risk, that disastrous downside for doing something that they were assured was lawful. So I think it's relevant that, because what we're talking about in immunity in part is what are the incentives it's going to create for cooperation between the private sector and the government in the future. There are lots of areas where the law is not crystal clear on exactly what private corporations can share with the government, can do to help the government, law enforcement, or the intelligence community in various situations. That's why the National Association of Chiefs of Police, 21 state attorneys generals, lots of other law enforcement organizations have supported this immunity, because it's a broad-based principle that's at stake here, which is the interaction and cooperation between private sector and the government. And when the government gives an assurance, this is what we think you can do, are they going to then back off from that and hang the companies out to dry?
On a gut level, do you think that your phone calls are listened to?
I don't think so.
Does it worry you?
No.
Mr. Rotenberg?
I don't think my calls are listened to, but it worries me that the administration believes it has the authority to listen to my calls without judicial approval. It actually worries me very much, because I think one of the great achievements we've had in this country over the years in the protection of privacy has been our very strong communication privacy laws. Actually distinguishes this country from many of the governments we've opposed in the past in Eastern Europe and communist countries that wouldn't grant their citizens such a right to have a private communication. We protect that right in this country, and so when we have a president who seems to believe that he doesn't need to go before a judge to listen in, I think that's a problem.
Well, I'd like just to respond to that, because we're not, comparing the United States and the program that the President announced, the terror surveillance program, to an Eastern Bloc nation, I don't think is accurate. We're talking about communications that were international to or from someone who's identified specifically as being suspected of being part of Al-Qaeda or a related organization. Those are the criteria of the program. This is not sort of the president thinks he can listen to anyone's phone calls without judicial authorization.
Well, to be fair, that's exactly what the argument is in the white paper that Mr. Philbin referred to earlier. The argument relies both on Article 2 in the Constitution, the authorization to use military force, and now it's being combined with immunity. So I think that's about as far as you can go.
Well, the House of Representatives now has the action, and coming up there, they have not passed any legislation, but they are about to at least consider a bill of some sort. Right. The President has encouraged them to pass the Senate bill. Majority Leader Hoyer spoke about this issue, and here's what he had to say, and I want to get your reaction.
This is not a political issue, it's a substantive issue of what does the Constitution require of us, and what does the law require of us in terms of granting immunity, as the chairman points out, to, if immunity is required, it's required because perhaps there was wrongdoing. If there was wrongdoing, we ought to know, as you've heard me say, what the wrongdoing was before we grant immunity for it.
Mr. Philbin.
Well, I don't think that whether or not Congress should grant immunity is simply a question of law. There is a question of policy here. It's not determined by law. It would be Congress making the law. I think that's the wrong way to approach it. And it is an issue of national security and more broadly national policy to ensure that the right policies are in place and the right incentives are in place, that the private sector will have the incentives to cooperate with the government in appropriate circumstances, both law enforcement and the intelligence community. And if you're talking about the narrowly defined set of circumstances at issue here, presidential authorization, assurances that the Justice Department has found that it's legal, that sort of sign-off on a program designed to thwart a terrorist attack on the United States, I think that the right policy is immunity should be given.
Marc Rotenberg, narrowly defined group of people who would be eavesdropped on, plus in the Senate bill there is congressional oversight provisions and FISA court provisions to check on the president's actions.
Well, I think with FISA court oversight, that certainly addresses some of the concerns about a role for the judiciary, and we support that. There are also minimization provisions that are important to ensure that the information that's being sought is being collected and not additional information. But I don't think it solves the immunity issue, and I think the key point, I mean, Mr. Philbin's right, there's a policy decision to be made here, and I think it comes down to two different views of wiretap law. One view of wiretap law says this is authority that is established by the Congress, overseen by the courts, and executed by the President. That's a very nice reflection of our system of checks and balances. Another view says it's an authority that the President has that he can implement, and that those who cooperate in his implementation are effectively immunized from any judicial review. I think that second approach is not one that's generally consistent with our constitutional form of government.
Any response?
Well, I don't agree with the general framing of the authority for conducting wiretaps. It was well established before FISA was enacted that the President had constitutional authority to conduct wiretaps without any court authorization. Every court of appeals that addressed that prior to 1978 agreed that the President had authority to do that. I'm not sure that that is really the relevant factor, though, for determining whether or not immunity is the right result here. I think that that turns on whether or not you want companies who assist the government in a time of public need to be able to rely on a representation about the lawfulness of something, and whether you want private litigation after the fact to be a mechanism for trying to provide oversight on intelligence activities. or whether you think that should be handled by Congress and private litigation is not the right mechanism.
Patrick Philbin is a lawyer with the firm Kirkland & Ellis. Are you involved in these lawsuits at all?
I'm not. I represent Verizon on some other matters, but I'm not involved in these lawsuits.
And Marc Rotenberg, what is the Electronic Privacy Information Center?
We filed an amicus brief in the Ninth Circuit in support of Hepting. That's the case against AT&T. And EPIC itself is a public interest research group here in D.C. I also teach privacy law at Georgetown.
And where'd you go to school?
I went to Harvard, then Stanford.
Yale undergrad and Harvard Law School.
We have been talking about immunity for telecommunications companies with regard to legislation that's currently working its way through Congress. Marc Rotenberg of the Electronic Privacy Information Center and Patrick Philbin, a Washington, D.C. lawyer, have been our guests.